Right now, somewhere in this country, a family is sitting around a kitchen table wondering why it has been 14 months and they still haven't heard a single word from USCIS. No interview notice, no approval, no denial, just silence. And every week that goes by, they are quietly losing ground. On job offers, on travel plans, on the ability to simply know what their future looks like. And the worst part? They don't know that there are legal strategies that could cut that weight down significantly, or in extreme cases, force the government to act. That's what this video is about. We are going to break down exactly how green card processing works in 2026, where the real bottlenecks are, and most importantly, what you can do today to stop losing time inside a system that does not slow down just because your case is stuck. Welcome to USA Immigration Path. I'm your guide through one of the most complex systems in the world, and if you've been watching this channel, you already know we don't deal in rumors here. While social media is full of noise, we are looking at the official text. We are checking the USCIS processing times tool, reading the policy memos, and tracking what attorneys are actually seeing in practice right now in 2026. That's the only way to give you information you can actually use. And before we go any further, an important reminder. Everything I share with you today is educational content. I'm an analyst helping you understand the system. I am not your immigration attorney, and nothing in this video constitutes legal advice for your specific case. Your situation has details that only a qualified immigration lawyer can properly evaluate. Please consult one before making major decisions. With that said, let's get into it. Let's start with the big picture. The green card process in 2026 is not one thing. It's a chain, and how long that chain takes depends on which link you're waiting on right now. If you're waiting on an I-130, that's the petition for alien relative, you're in the family-based lane. If you're waiting on an I-140, that's the immigrant petition for alien workers, you're in the employment-based lane. And if you're waiting on an I-485, that's the application to register permanent residence, also known as adjustment of status. You're at the final stage, trying to convert your status to that of a lawful permanent resident while you're already inside the United States. Each of these forms has its own processing time, its own service center, and its own set of complications. And the clock on each one runs separately. So let's look at the facts, not the fear, when it comes to current processing times. For the I-130, the numbers vary dramatically depending on who is sponsoring you. If a U.S. citizen is sponsoring an immediate relative, a spouse, a parent, or an unmarried child under 21, current processing is running roughly 10 to 14 months on the higher end when filed separately. But here's an important strategic note we'll come back to. If you're inside the United States and eligible to file both the I-130 and the I-485 at the same time, what attorneys call concurrent filing, the combined timeline tends to run around 8 to 14 months, and that is faster than doing them in sequence. That's a real strategy, not a shortcut. Now, if a lawful permanent resident, a green card holder, is sponsoring a spouse or child, the situation is considerably more difficult. We're not just talking about processing times at that point. We're talking about visa number availability, which is governed by something called the Visa Bulletin, published by the Department of State every month. For green card holders sponsoring family members, that wait can stretch to 35 months or more just for the I-130 to be processed, and then the visa number situation adds another layer entirely. That's why anyone in the F2A preference category, spouses and minor children of permanent residents, should be checking the Visa Bulletin every single month. That document can literally tell you whether you are months ahead of or behind where you need to be. For the I-140 in the employment-based categories, the picture is more varied and, in some cases, more hopeful. Standard processing times depend heavily on which service center is handling your case. The Texas Service Center handles many employment-based I-140 petitions. The Nebraska Service Center handles others. Processing at these centers for standard I-140s can currently run anywhere from several months to well over a year depending on the EB category, EB1, EB2, or EB3, and the specific subcategory. This is where the conversation about premium processing becomes critically important, and we're going to get into that in detail in a few minutes. For the I-485, family-based adjustment of status is currently running around 8 to 10 months at the median. Employment-based I-485 processing varies significantly based on visa number availability and priority date movement, and in some categories it is genuinely moving faster than in recent years. But here's something that most applicants miss, and it matters a lot. Stay with me, because this next detail affects your timeline more than almost anything else. Your I-485 timeline is not just about USCIS processing. It's about the combination of biometrics, background checks, your underlying petition being approved, and, critically, whether your priority date is current in the visa bulletin at the time your I-485 is ready to be adjudicated. If your priority date becomes unavailable, what's called visa retrogression, your case can effectively freeze even if USCIS has everything else it needs to approve you. This is one of the most painful and least discussed realities of the green card process, particularly for applicants from high-demand countries. If you're from India or China in the employment-based categories, your wait for a current priority date alone can span years or even decades in some preference categories. The processing time at USCIS is, in those situations, almost a secondary concern. And there's one more layer here. Your case's processing time is tied to the service center listed on your receipt notice, the Form I-797C. And USCIS sometimes transfers cases between service centers to balance their workload. When that happens, your applicable processing time shifts to the new location. A lot of applicants don't realize that and end up calculating their wait against the wrong office. The receipt notice in your hand tells you where your case is. Always verify that against the current USCIS processing times tool at uscis.gov before drawing any conclusions about where you stand. Now let's talk about one of the most powerful tools legally available to cut your wait time, premium processing under Form I-907. And I want to be very direct here about what it can and cannot do, because there is genuine confusion about this. Premium processing is available for certain employment-based petition types. As of 2026, you can request premium processing for Form I-140 immigrant petitions in most employment-based categories, and for Form I-129 non-immigrant worker petitions in most classifications. You cannot request premium processing for the I-130, the I-485, the N-400, or the Perm Labor Certification. Those forms do not have a premium option, period. When you file Form I-907 requesting premium processing for an eligible I-140, you are paying an additional government fee, currently $2,805 for most I-140 and I-129 categories, and in exchange, USCIS guarantees they will take action on your petition within a specific time frame. For most I-140 categories, that guaranteed action time frame is currently 15 business days. Now, I want to be precise here. Action means USCIS will issue an approval, a denial, or a request for evidence within that window. It doesn't guarantee an approval. But for employers trying to secure a worker's status, or for an employee who is trying to get their I-140 approved so they can protect their priority date, or begin the next stage of their green card process, the difference between waiting potentially a year on standard processing versus getting a response within 15 business days is enormous. Here's a real-world scenario that illustrates exactly why this matters. Take a software engineer. Let's call her Priya. She's been in the U.S. on an H-1B for 4 years. Her employer has started her EB-2 green card process, and the I-140 is the critical step because the date that petition is received, her priority date, determines her place in line for a visa number. The earlier that date, the better her position. Every month that goes by without an approved I-140 is a month she isn't protecting a priority date. For someone in Priya's situation, paying $2,805 for premium processing and getting that I-140 approved in 15 business days instead of potentially 12+ months on standard processing isn't a luxury. It's a strategic investment that could meaningfully affect when she ultimately gets her green card. But this is where it gets complicated. And I see a lot of applicants make a costly mistake right at this juncture. Premium processing does not prevent a request for evidence. An RFE is when USCIS reviews your petition and determines that something is missing, unclear, or needs additional documentation. And when an RFE lands, it stops the clock. You now have a response deadline, typically 87 days. And if your response is incomplete or arrives late, you're looking at a potential denial. Premium processing just means USCIS looks at your case faster. If they look at it and find a problem, they'll send that RFE faster too. This is why the strategy of front-loading your application, submitting an exceptionally thorough, well-documented initial petition, is arguably the single most impactful thing you can do to minimize your total wait time, not just for premium processed cases, but for any petition you file. What does front-loading actually mean in practice? It means anticipating every question USCIS could possibly raise about your eligibility and answering it before they have to ask. For an I-140 in the EB2 or EB3 category, that means submitting not just the minimum required evidence of the job description, educational credentials, and labor certification, but also comprehensive supporting letters from supervisors, detailed descriptions of job duties that clearly align with the claimed specialty occupation, multiple forms of evidence of educational equivalency if applicable, and organized, tabbed exhibits that make the officer's review as straightforward as possible. For a family-based petition, it means submitting abundant evidence of a bona fide relationship from multiple independent sources, photographs, joint financial records, lease agreements, travel records, communications. Not just what's required, what's comprehensive. The math here is simple and sobering. An RFE adds weeks, often months, to your timeline. Attorneys who handle high volumes of these cases report that thorough initial filings dramatically reduce RFE rates. Spending extra time and, if applicable, attorney fees to build a rock-solid initial submission is almost always cheaper in time and money than responding to an RFE after the fact. Think of your initial petition as a legal brief, not a form submission. It should leave no reasonable question unanswered. Most applicants spend their energy worrying about processing times and overlook this entirely. The quality of what you submit on day one has more control over your timeline than almost anything else you'll do in this process. Now, let's say you've done everything right. Your petition was thorough, you didn't get an RFE, you filed on time, and yet months turn into a year, and a year turns into longer, with no movement and no explanation. USCIS simply isn't acting on your case. What then? This is where we need to talk about a legal remedy that more and more applicants are turning to in 2026, and that most people have never heard of until they're desperate: the Writ of Mandamus. A writ of mandamus is a federal lawsuit. When you file one, you are asking a federal district court to issue an order compelling a U.S. government agency, USCIS, or in some cases the State Department, to perform a duty they are legally required to perform. In immigration cases, that duty is to adjudicate your application within a reasonable period of time. The Administrative Procedure Act, a federal statute, is the legal foundation here. It mandates that when Congress assigns an agency a task, that agency must complete it within a reasonable time. When USCIS sits on a case for years with no explanation and no action, they are arguably violating that duty. To qualify for a mandamus action, your situation generally needs to meet 3 conditions. First, you must have a legal entitlement to a decision, meaning you filed a properly accepted petition that USCIS is obligated to adjudicate. Second, the delay must be unreasonable, not just frustrating, but demonstrably beyond the normal processing time for your case type. Third, you must have exhausted the normal administrative remedies, meaning you've submitted case inquiries through the USCIS e-request system, tried contacting your congressional representative's office for a congressional inquiry, and possibly engaged the USCIS ombudsman before escalating to federal court. Mandamus is not a first resort. It's a last resort after the normal channels have failed. What does it cost? Filing a new federal civil action carries a court filing fee currently around $405. Attorney fees on top of that typically range from several $1,000s to $10,000 or more, depending on the complexity of the case and whether the government contests it. And here's something attorneys in this space consistently report. In a significant number of mandamus cases, the government does not want to litigate. Once a lawsuit is filed and served, USCIS often moves to adjudicate the long-pending case relatively quickly to avoid the court battle. The act of filing itself frequently prompts action. That's not a guarantee. Every case is different. but it explains why more than 7,000 mandamus lawsuits are filed against USCIS and the State Department every year, and why that number keeps growing. And critically, this is something a lot of people fear and shouldn't. Filing a mandamus lawsuit is a legal right. The law prohibits retaliation for exercising that right. Judges review these cases independently. USCIS is required to continue processing your application normally. The legal community's consistent experience is that filing a well-constructed mandamus complaint does not hurt your immigration case. It pushes it forward when nothing else has worked. Let's look at the facts, not the fear. One more time here. Mandamus is not for someone whose case is at 12 months and within normal processing times. It's for someone whose case has been sitting for 2, 3, 4 years with no explanation, where every inquiry has been met with under review and where the delay is genuinely causing measurable harm, lost job offers, family separation, inability to travel, uncertainty that is destroying someone's ability to plan any aspect of their life. So, let's bring this together into 3 concrete steps you can take right now, today, regardless of where you are in the process. Step 1. Go to USCIS.gov and use the official processing times tool. You need 3 things to use it correctly: your form type, your form category, and the service center listed on your I-797C receipt notice. Do not estimate. Do not rely on what someone told you in a Facebook group. Pull up the tool, enter your specific information, and find out the actual case inquiry date for your situation. If your receipt date is earlier than that inquiry date, you are eligible to submit an online service request through your USCIS online account. That's not a guarantee of acceleration, but it's a documented inquiry on record, and it's the first step in the administrative process you'll need to demonstrate if things escalate later. Step 2. If you have an employment-based petition that is I-140 eligible and you haven't already filed, or if you're in a position to refile with an employer, have a serious conversation with your attorney about premium processing. The fee is significant, but the 15 business day action window can be transformative for your timeline and your priority date protection. And if you are preparing any petition right now, treat front-loading as non-negotiable. Before you submit anything to USCIS, ask yourself and your attorney, is there any question an adjudicating officer could reasonably ask about this case that we haven't already answered? If the answer is yes, keep building. An RFE costs you more time than the extra preparation ever will. Step 3. If your case is significantly outside normal processing times, if your congressional inquiry went nowhere, and if the delay is causing documented hardship in your life, consult with an immigration attorney who has specific experience with mandamus actions. Not every attorney handles federal litigation. Ask specifically whether they've filed mandamus petitions in federal district court and what their experience has been. This is a specialized area, and you want someone who knows the procedural requirements, the correct venue, and how to structure a complaint that gives you the best chance of prompt government action. Immigration policies shift overnight. Processing times move. Visa bulletins change every month. Service centers transfer cases. New fee structures take effect. And in the current environment, staying informed isn't optional. It's protective. The difference between an applicant who understands the system and one who doesn't isn't just stress. It's months, sometimes years. That's why this channel exists. Subscribe now so you don't miss the next update. Hit the notification bell so these videos reach you when the information is fresh. And if someone you know is stuck in the system, share this video with them. The best thing you can do for someone navigating immigration in 2026 is make sure they're working with real information. We'll see you in the next one.